This case was a bit of a roller coaster to watch and very unexpected. So instead of giving you the background summary, I'm just going to let you watch it and take the same journey I did, trying to figure things out.
Who do I have joining me from the jail? You in orange. What's your name?
Oh, this is James.
What's your name?
I said James.
Winhoven?
Yeah, correct.
Okay. All right. This is in the matter of James Edward Winhoven, file number 23-21410FC. I have Timothy Churchill appearing on behalf of Mr. Winhoven, and I have Isaac Sneed appearing on behalf of the people. It does appear that this is the date and time, double check, for arraignment in this matter. Mr. Churchill, do you and your client waive the reading of the felony information?
Yes, good morning, Your Honor. I would waive a reading of the formal information. Client would stand mute.
Okay. Have you received a copy of the people's request for discovery, felony information, and witness list?
Yes, I have, Your Honor.
All right. And are you asking the court to enter a plea of not guilty on your client's behalf?
Yes, I am, Your Honor.
All right. So, Mr. Churchill, this morning, Mr. Coast from Pretrial Services contacted us and prepared a motion affidavit and bench warrant. We weren't quite aware at the time that he was in custody because our records didn't show him in custody because his GPS tether was removed on July 3rd of 23. The device was returned to JSG monitoring without getting it put back on. And I'm not sure what day he was taken into custody, but obviously he's in custody now. So what is he in custody on, Mr. Churchill?
Well, Your Honor, he's in custody right now on the 2 charges in this complaint. I had thought this is kind of an unusual situation. If you can bear with me a moment here. His bond was originally set in the amount of $100,000, 10%. That bond had other conditions too, that if he were released from jail, he'd have to have a monitor on, which he did. After the bond was set, about 4 days later, the victim found out the bond was reduced, had a fit, contacted the prosecutors, wanted bond reviewed, and the district court judge moved bond back where it was. He was then incarcerated. After posting, it was reduced to $5,000 cash, which was paid and then refunded after he was rearrested.
Hold on, Mr. Churchill. So the victim in this case requested a bond hearing?
Yes, was upset with the bond. We had a hearing on that last.
Hold on. Was there a bond hearing where his bond was raised?
Yes, back to the original amount.
Okay, got it. All right, go ahead.
Okay, well, as I said, his bond was reduced to $5,000. He got out. There were no problems, but the victim was upset, so it went back to $100,000 with the bond condition of the tether. He got arrested on the 27th, but due to his special medical needs and the fact he's autistic and on SSI and has autism and was having some major medical issues going on, you'll see a memorandum in the file where Judge Shadler stated that the parents could appear at jail and transport him to his medical appointments, which they did on July 3rd. He had an MRI of the brain that was scheduled a week and a half before that, but it was involved having to have a radiologist there for dye and contrast and all that. He was taken, and when they got him to the hospital, they found out he still had his tether on. So the tether had to be removed because he couldn't have any metal on to go in the MRI machine. And the parents didn't realize that until they were ready to put his gown on. Normally when they get returned to jail, they don't leave a GPS monitor on. And that's something we might need to deal with for future medical appointments. But so anyway, that's where we're at in regard to the bond issue today. And I was going to further ask if the court would consider a reduction in bond because of defendant's kind of unusual situation here. If I may allocute on that a second, Your Honor.
Well, Mr. Sneed, are you prepared to address bond in this case today?
No, this information is all new to the people, at least for me as of this morning. I'm covering for Mr. McCready. He'll be back in the office next week. I'd ask if the court would like to entertain a bond hearing that we have some time to maybe discuss this with Mr. Churchill about the conditions and follow up with the victim again regarding the current circumstance of the tether removal.
So, Mr. Churchill, because this is first appearance in front of me, and I only have a felony information, so I don't have much more information than that and what you've given me. I think in this case, I can set this for a bond hearing so that the people have an opportunity to respond. It appears that there's potentially a victim who would like to speak as well at the bond hearing. So, and I do have them in the courtroom and they would like an opportunity to be heard through the prosecutor as well. So I'm not going to address bond at this time, but I can give you a date for that and you could submit a sentencing or a bond motion and allow the people to respond, Mr. Churchill.
Okay.
Miss Adams, I'm looking for July 17th, something during the week of July 17th for about 30 minutes. Could be Monday, Tuesday, Wednesday.
Your Honor, could the court allow me to run and grab my schedule? It's 2 offices.
Sure.
Over. Okay, sorry. I didn't
Sure.
have- okay. Momentarily. I'm back, Your Honor. The 17th is fine if it's in the morning.
No, Mr. Churchill, I'm waiting for Miss Adams to give us a date that week. Hold on.
Judge, we could do Tuesday, July 18th at 10 a.m.
Mr. Churchill,
Yep, that'll work.
Mr. Coast, or I'm sorry, Mr. Coast, I know you're here. Mr. Steen
That Tuesday, July 18th.
at 10 a.m.
Yes, that's fine for the people.
All right, so I'm going to set it for bond hearing and pretrial conference on July 18th at 10 a.m. And is there anything else? And I'll enter a plea of not guilty on his behalf. And we'll see you back July 18th at 10 a.m.
And
Thank
there's
you.
a few other things I want to advise the court of. I will be talking to the prosecutor to stipulate to filing a motion to have the defendant forensically examined for competency and criminal
So,
responsibility.
okay, so Mr.
Just to
Churchill,
let
you're
you know
making
where
a,
this is heading.
hold on. So Mr. Churchill, you're making a motion for forensic examination as to competency as well as criminal responsibility.
That is correct, Your Honor. Yes.
All right, so I need you to submit the paperwork for that today.
Okay.
Mr. Sneed, any objection to that?
No, Your Honor. Thank you.
All right, so Mr. Churchill, you could submit the request for competency as well as criminal responsibility. I think those take about 60 days. So go ahead and submit that. I'll need 4 copies of each request.
Okay.
And then I'll
will-
sign them. I'll sign them on receipt. And then they'll get returned to you and you can send that, a copy of each of those plus a copy of the police report to the forensic center.
Okay, very well. And one other thing I wanted to advise the court of, my clients advised me that the victim in this matter is the niece of the chief prosecutor there. And maybe asking me to file a motion to disqualify the prosecutor in this case because of the relationship with the victim and Ms. Weiss, the chief prosecutor. But I've not, that just came to my attention this morning. I've not had a chance to address it.
Okay, Okay, Mr. Sneed, all right, so Mr. Churchill, you can file that motion and have it ready for the 18th as well.
Very well.
Mr. Sneed, do you have any information on that?
I'll have to look into that, Judge, and we
Okay.
can reply to the motion accordingly. Thank you.
Okay, all right, so Mr. Churchill, you can submit that motion for July 18th as well.
Very well. Okay, thank you, Your Honor. I'm sorry, we had it down at 10 o'clock. District said be here at 10 o'clock for arraignment on the 5th, and I guess you were calling me earlier and,
My arraignments are 8:30 in the morning.
okay, I was given time for the input.
I'm sorry, District Court gave, it's okay, District Court obviously gave me the wrong date and time. All right, so we'll see you back on July 18th at 10 a.m. Thank you.
Good. Thank you, Your Honor. Have a good day.
Okay, so after watching that, I really didn't know what to think. Disability, possible competency issues, bail revoked because of the victim, and she's the prosecutor's niece. I was a little confused, but then I realized I didn't even know what he was charged with. So, of course, I had to look that up. And he has 2 charges. The first one is kidnapping. The second one is criminal you-know-what conduct, assault with intent to commit you-know-what penetration. I haven't seen that one in a while. So that's pretty intense charges. Okay, so maybe it kind of makes sense that he's locked up. And if it was that serious of charges, was there something in the newspaper? Gotta Google that too. I ended up on Facebook, and on Facebook there was this post. It was actually made by the victim. And there is a picture of a flyer that is posted on a corkboard. And in case you can't read it, it says, one of our workers was physically attacked on 6/15, and while the attacker was arrested, he was then released back into our community on a small bond. We need to come together and protect our community. Call the prosecuting attorney's office at phone number and let them know that we, as a community, are not okay with this. If there is no answer, please leave a message. Tell them that you do not feel safe with James Winhoven out in our community. And there's the little hangy tags to pull down the phone number. And I said, okay, that's unusual. And the message at the top is actually from the victim as well. I've copy and pasted it. These are not my typos, so don't yell at me. I will own my typos, but these aren't mine. I'm asking anyone to please message me with any info on James Winhoven that could be useful to put him back in jail. Even if you think it's small, anything will help, as most people know they let him out. He was very clear with what he was planning to do to me, had no problem telling cops that it was him and his motive was kidnapping and to R-word me. No, I wasn't his first victim either, but who's next if we don't work together to put him back where he belongs? So please, anything. Anyone has or knows someone that has info that will help, please message me. I thought that was a little interesting too. You don't usually see a victim posting on Facebook. And then I scrolled down and it just so happens that there is a video of the actual attack posted by the victim on Facebook, along with several photos of the defendant. And she posted the exact same message at the top of that Facebook post. And this is the video of the attack. As you can see, he drags her off camera over to the right. It appears that it's actually a cop like recording the security camera feed, and that's who makes the comment about the counter. But then the defendant runs back in front of the counter and out the door, and the victim is chasing him. So she chased him out, and I think the entire video is less than 30 seconds, and that is the entire incident from what she is saying. So I don't know what to think. What do you guys think? Should he have been put back in jail with his bond conditions changed? And have you ever heard of a victim being able to get a bond reconsideration hearing? Because I don't think I have. let me know. Thanks for watching as usual.